Welcome to Shenkman Education. My name is Marty Shenkman. At the topic of this video clip is what is an executor? What is the role of an executor? Everybody probably knows that an executor is the person appointed in a will to administer an estate. Even if you're doing a revocable trust and trying to avoid probate and you use different titling to assets to avoid probate, you still need a will, at minimum a pour of a will that pours into your revocable trust, and you need to name an executor. It is not possible to know with certainty that every single asset you have will be handled without an executor. The executor is the person named. It's often called a personal representative. There may be other names. The person serves in a fiduciary capacity, and there's another video clip about what that means and the cautions and duties that an executor as a fiduciary owes to the beneficiaries and to the testators' wills and wishes. What are the duties? What are the roles of an executor? First, very important, every estate is different. Everything is going to depend on the circumstances, the assets, the people involved, and so on and so forth. Be very careful following any guidance that says this is exactly what you do. Yeah, this may be generally what you do, but you need to be alert to what's unique to the circumstances you're involved in. If it's a really big estate, you're going to have more complex legal and tax issues. If it's a really small estate, you're going to have to be more conscious of costs and fees involved and the need for beneficiaries to get money faster to pay for expenses that they may have. There's a myriad of different circumstances. General steps that have to be taken. One of the first steps is you have to identify all the family members. Even if the person is leaving assets to non-family members, you may still have to identify family members because they may, in the absence of a will, have rights under state law, may be entitled to notice. And you need to understand what the law in the state where the will is being administered requires. So you got to identify family members, and today, in this day and age, it may be more than just family members. There may be other people. What I would suggest you do is you draw a family tree and go back a generation or two out, at least a degree or two. Go through the legal documents involved, the will, if there's a revocable trust, that too. Identify all the different people named, get their contact data, and find out if there's any relationship or no relationship, just so you know. And you really probably should consult a lawyer, but you could probably get the statute online. But you got to make sure that if there's any notice requirements, the appropriate people are noticed, and it's going to be exacting. If the law in your state, or the state rather, where the will is being administered requires that notice be given certified mail, do exactly what the law says. Don't try some variation law. Well, I knew him, I just handed it to him. Do exactly what the law says. You have to get the will admitted to probate. That can involve a wide array of different things depending on the state, the county, the surrogate's court, in terms of time and cost. In some areas of the country, it's really not that big of a deal. You take an original will, an original death certificate, a couple of blank checks to pay for the court fees, and there's usually some type of information sheet. In other courts, it's almost assumed that a lawyer will do it. Maybe you can do it on your own. Many of the courts, some of the courts are severely backlogged. It could take quite some time. Also, if you're trying to avoid probating the will, think about it carefully, especially if you're the named executor. If you're the executor, you don't have authority to act if that will's not probated. In the court, the surrogate or probate court, sometimes it's called orphans court, different names in different jurisdictions, that court has to issue you an official document called letters testamentary, which authorize you to act as an executor. So be very careful trying to avoid probating the will if you may have to take any actions. So we've talked about people, we've talked about probating the will, and by the way, probating the will, in some instances, finding the original will and making sure it's the most recent one alone can be a challenge. You then have to identify all assets, all liabilities, all expenses that have to be paid. And you have to safeguard all of the assets. So this is not something to be lackadaisical about. If you're the executor, personal administrator, and somebody dies and you're named executor, you got to find out what their assets are, and you got to find out how to protect them. So for example, change the locks on homes and vacation homes so that no one goes in and starts pilfering assets. It happens with frequency. If there's a safe deposit box, identify it. You probably can't get access until you have letters testamentary after probate, but find out where it is located. Find out if other people are named to have access. You don't want somebody else to empty out the safe deposit box only for you to then find that assets in that box, like jewelry, will be bequeathed to other people. In the process of safeguarding assets, make sure insurance is updated. If somebody passes, contact the property liability casualty insurance companies and make sure you update the coverage to list the estate. Many people don't update their coverage, and the dollar values of coverage may be woefully outdated. Inventory the assets. In many cases, we've hired companies or had the estate hire a company of professionals that comes in and inventories, makes a detailed listing and photographs every single item in a house, in a safe deposit box, in a vacation home, in an office. This way you have a detailed record of everything that's there. And again, be careful just saying, well, everybody gets along and I don't need to go through that, and why spend the money? Because you may be liable. And by the way, having proper detailed records may also enable you to avoid fights between heirs, because it's not conjecture, you have the facts. Identify and pay all expenses. You probably want to call and cancel all credit cards of the decedent, find out if there's line of credit, home equity lines, other types of liabilities. For a more complex estate, there could be guarantees that are not so easy to identify, and you need to know them before you make asset distributions. Conflicts, disputes, so often, tragically, arise between heirs that are named and people that thought they were going to be heirs. Try to identify any potential issues and see if you can reasonably deal with them to try to reduce the likelihood of lawsuits and claims, which often hurt everybody and are very costly in our public affairs, because if somebody files a lawsuit, it's public record. So all the efforts to keep things quiet just don't tend to work. Once you know all the liabilities and expenses are paid and the assets are secured, you probably should hire an accountant, because there are complexities with the final income tax return for the decedent, selecting a tax year for the estate, filing an estate tax return, and even if your estate's small, you may want to file a return for portability. That's a different topic we're not going to get into here, but there's a lot of obligations, responsibilities that could be important for you as the executor, the estate, and even the beneficiaries, and certainly a surviving spouse if there is one. So consider hiring an accountant. I don't think that this is something that is that easy for a layperson to figure out. And you're probably better off getting the right help. It may be much cheaper, much cheaper in the long run. Make sure all tax returns are filed and taxes are paid. You want to do that before you start doing the next thing, which is distributions. You don't want to distribute assets and find, oh my, now there's expenses and I don't have enough money as the executor to pay for them. Consider using a release, receipt, and refunding bond, where each person getting a distribution signs off first saying, I got a copy of the will. You want to look at what state law may require in terms of notification. Many beneficiaries are entitled to a copy of the will. Make sure they get a copy of the documents. They sign off saying that they got it. They understand what their bequest or inheritance is, and they acknowledge receiving it. And they agree that if there's expenses on the estate that could exceed assets of the estate, they'll refund a proportionate amount of their distribution to pay those expenses. That is never easy to do, which is why I stressed earlier, you want to have all the expenses paid, or at least acknowledged and calculated, accounted for, and taxes taken care of before you make a distribution. But it still may be prudent to have that receipt, release, and refunding bond, and you probably want to have a lawyer do that as well. If there's charitable beneficiaries, check state law, but in a lot of cases, depending on how a charitable beneficiary bequest is worded, you may need the approval of the state's attorney general for the distributions from the estate. And you don't want to risk violating that. Conceptually, in some cases, if a charity gets $10,000, $100,000, whatever the number is, it's a fixed dollar amount. That may not, but check state law, require any kind of involvement of the attorney general. But if the estate, if there's 3 kids and 1 charity, and the estate is distributed 25% to each child and 25% to the charity, the Attorney General may more likely have to get involved in that, and you want to make sure that if there's an approval process, you adhere to it before making distributions. Please keep in mind that this is really just a high-level overview trying to give you some better understanding of the role and responsibilities of an executor or personal administrator under a will. Every circumstance is different. State laws are different. Family dynamics, whether and however families defined, can be very different. Just identifying family members can be quite complex depending on the definitions in state law and the legal documents. Is somebody born by artificial reproductive technology, ART? Are they recognized as a child? Somebody adopted? What if they're adopted after age 18? Are they recognized as a child? It depends again on the governing instrument, the will, and state law. So just things that seem obvious may not be so obvious. And you want to be proactive to protect the heirs, to protect the assets, and protect yourself as fiduciary from liabilities. Please keep in mind that all the information in the video clip is for educational purposes only. Don't take any action without appropriate professional guidance. For more information, see www.shenkmaneducation.com. Thank you.